The U.S. Department of Homeland Security is reportedly considering shutting down Customs and Border Protection processing for certain international flights and redirecting those passengers to other international airports. And if the rationale they've given for doing that is the true reason, they're in some pretty serious legal trouble. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. The problem here isn't that the federal government lacks authority over immigration and customs. The problem is the reasons that they've offered for why they're doing it. Under U.S. law, government agencies can't just make decisions because they feel like it. In the same vein, they can't use government power as a political weapon. They have to act for reasons connected to their lawful mission, and they have to be able to explain those reasons in terms that are not clearly political. To use terms directly out of constitutional law, this is a prohibition on arbitrary and capricious government action. The U.S. Supreme Court has repeatedly held that agencies must examine the facts, consider relevant evidence, and provide a rational explanation for what they're doing. And that makes really good sense, even just from a practical standpoint. If they change course, they have to explain why. If they ignore important facts, if they rely on inappropriate considerations, or if they offer explanations that don't match reality, courts can strike their actions down. And that's likely to apply here. If DHS had just come out and said, hey, we're closing CBP processing at particular airports because of staffing shortages or security concerns or infrastructure limitations or some other legitimate operational reason, they probably would have gotten away with this. But they've offered a specifically political reason. If the goal is to punish a city, a state, or a local government, or any other segment of the population that the administration dislikes politically, they can't do that. That is a violation of the arbitrary and capricious standard. The same thing goes for situations where the objective is simply to make international travel more difficult for people living in certain communities. The legal justification that Markwayne Mullin has offered for these state actions negates the state actions unto themselves. The Supreme Court has made it clear that agencies cannot rely on factors Congress never authorized them to consider. Congress gave Customs and Border Protection authority to inspect travelers, enforce customs laws, and secure the border. But Congress never gave CBP the authority to punish political opponents or reward political allies. The courts are not required to accept pretextual explanations either. If the official justification doesn't match the evidence, judges are allowed to look behind the curtain. But Markwayne Mullin didn't even do that here. He was very open. He just said, we're going to punish liberal cities. And that is a per se violation of the arbitrary and capricious standard. At the end of the day, due process is about more than just procedure. It's about preventing the government from exercising arbitrary power. The federal government can absolutely make policy choices. It can change priorities. It can even reverse policies. But it cannot simply use the machinery of government to advance political grudges and then call that administration. If DHS is closing CBP processing locations for legitimate operational reasons, it should be prepared to prove that. But it's already come out and said explicitly that it's not. And that is the exact kind of arbitrary and capricious government action that the Constitution and administrative law do not allow.